Good morning, everyone. My name is Henry W. Green. I will be the presiding judge for this case that we have right now. And let me introduce the other judges that are here with me, G. Gordon Atchison and J.C.J. Hurst, both of the Kansas Court of Appeals. Let me call the case that we have for this morning. Roger E. Hendrix, appellee, and Barbara Bartell and John Bartel, appellants. I'd like to get the appearances of a counsel appearing for the appellant. Would you state your name?
May it please the court, Your Honor, Richard E. Dietz, Dietz and Hardman Law Office, Osborne, Kansas, for the appellants.
Fine. Appearing for the appellee.
May it please the court, Your Honor, Chasen R. Katz on behalf of appellee Roger Hendrix.
Thank you. Before we get started, I would like Mr. Dietz for you to tell the audience a little bit about the case. And when you do, that time will not be used against you. This case has been set for 15 minutes. And before I get started, Mr. Dietz, do you want any rebuttal time?
Yes, Your Honor, I would request 3 minutes of my oral argument time for rebuttal.
Okay. Now, if you can give the audience a little overview of what this case is about. And again, I mentioned you won't be using up any of your main time that you have. You're going to have 12 minutes as far as with your main argument and 3 minutes rebuttal.
Thank you. May it please the court, I am legal counsel for Barbara Bartell and John Bartel, referred to as the Bartels in the appellant's brief and in my oral argument today. The appellee defendant Roger Hendrix will be referred to as Mr. Hendrix or the proponent in my oral argument. The dispute in this case is about the validity of a transfer on death deed executed by a gentleman named Wendell Woodard. Mr. Woodard owned approximately 700 acres of farmland in Osborne County, Kansas on the date of his death. On September 17 of 2018, Mr. Woodard signed a transfer on death deed, which is the subject of this action. The appellant, Barbara Bartell, is a niece of Mr. Woodard, the maker of the transfer on death deed in question. And appellee Roger Hendrix is a nephew of Mr. Woodard. Appellant John Bartel is Barbara Bartel's husband. The Bartels claim that the transfer on death deed at issue in this case was the result of and a product of undue influence exerted on Mr. Woodard by Mr. Hendrix, and a result of such undue influence, the transfer on death deed is invalid. The Bartels are before this court contending that the district court erred in its finding that the Bartels did not meet their burden of proving by clear, satisfactory, and convincing evidence of suspicious circumstances surrounding the creation of the transfer on death deed executed by Mr. Woodard on September 17 of 2018. In analyzing the issue of undue influence in Kansas, the doctrine of suspicious circumstances is applied to determine if there is a presumption of undue influence. That determination is made by the application of a two-pronged test.
Excuse me, Mr. Dietz, I think that's a fine summary. And I just want to give you a warning. I'm about ready to start your time.
Thank you very much, Your Honor. The determination to be made of suspicion, the finding of suspicious circumstances in an undue influence test or an undue influence case is dependent upon a two-pronged test. The first prong of that test is, was the proponent of the instrument in question in a confidential and fiduciary relationship with the maker? And second, were there suspicious circumstances surrounding the creation and execution of the instrument in question? In this case, the transfer on death deed that was executed by Mr. Woodard on September 17 of 2018. The first prong of the test to determine.
Mr. Dietz,
Yes,
I want to just stop you for a second. In reviewing this case, I'm aware of that standard. The standard I would like you to talk about, though, is our standard on appeal for reversing the district court's decision. So can we start with addressing why you think the district court's decision, we can reverse that decision?
thank you, Your Honor. Your Honor, the position of the appellants is that the district court erred by arbitrarily disregarding undisputed evidence, which substantially proved undue influence in this case. There was an arbitrary disregard for undisputed facts presented to the court in this case, which supported a finding of suspicious circumstances
And Mr.
surrounding.
Dietz,
Yes,
then are you saying you are not arguing bias on the part of the court or another provision of that standard, just that they arbitrarily disregarded some of the facts?
that is true, Your Honor. The appellants are not arguing that there was bias or prejudice. We're arguing arbitrary disregard.
Okay, go ahead.
The first prong of the test, the finding of a confidential relationship, was found in this case by the court. That's not an issue. It's obvious in reading the transcript that the district court found that was very obvious. Mr. Hendrix even testified, essentially admitting that he had a close and confidential relationship with Mr. Woodard. Again, the issue in this case is the second prong of the test. And the Bartells, again, submit that the district court arbitrarily disregarded undisputed evidence, which taken together created a chain of circumstances, which we contend establish suspicious circumstances. And what I would like to do then is consider the evidence which was elicited at trial and how the district court responded in regard to that evidence.
And Mr. Dietz, I would suggest, can you identify what the district court disregarded?
I will, Your Honor. I'm going to go through what we contend are undisputed facts, and I'm going to contrast that against how the district court considered that.
Okay. All right.
Okay. The first undisputed fact. Dr. Brown, Mr. Woodard's physician, testified that Mr. Woodard had cognitive issues and that he had dementia.
I'm sorry, Mr. Dietz, did she testify that he had dementia?
Yes,
Okay. It was my understanding that she testified that there were some issues, but he had not actually been diagnosed with dementia.
she did not say that he hadn't been diagnosed. She testified that from her observations as the physician who was called to treat patients or people who were living at the long-term care facility, that he exhibited dementia. She commented about his thought processes and that she considered him as exhibiting dementia. Yes.
Okay, so exhibiting some symptoms of dementia, but not having been diagnosed with dementia.
There was not a document that says from the doctor, I diagnose Mr. Woodard as having dementia.
Can you
But
talk
she
about
listed
some of
that-
the, go ahead and talk about some of
She
the things
listed
that
that
she,
in notes that were admitted as evidence. Yes,
in a memo.
that is
in
correct.
one.
A memo.
Correct. Can you talk to me a little bit about what signs she felt were evidence of dementia?
if I recall in reading the transcript of her testimony, she said that comments that he made, many things that he said, just the way his thought processes indicated dementia to her.
Okay. All right, go ahead.
In response.
Mr. Dietz, well,
Yes.
on that point, the district court made a very lengthy, and I would say thorough bench ruling. I mean, there wasn't a written findings of fact and conclusions, but I mean, didn't the district court talk about the medical doctor's reference to dementia, and then the district court contrasted that with the testimony of the nurse, and I'm drawing a blank on her first name, McEwen, who had daily interaction with Mr. Woodard, and the district court specifically credited Nurse McEwen in that situation. So how does that fit into an arbitrary disregard of evidence? I mean, it might be that you disagree, and it might be that we would disagree and say, well, you really ought to credit the medical doctor, but that's not, the district court didn't do that. I mean, the district court made a very specific credibility determination here on that point, didn't it?
I do not agree, Your Honor. He did talk about, in fact, I'm looking at what the judge said, really. He said, well, he based his response to Dr. Brown, the physician's testimony, based on really, well, Mr. Hendrix, which would be very self-serving, said he understood he was a very stubborn man. He was hard-headed. He knew what he was doing. The nurse that was there in the room doing the notary, who is Mrs. McKeon, said that it appeared that he knew what he was doing. But you contrast that against the physician. And again,
well, let me stop you right there. I mean, that's the point, is it's contrasting these conflicting accounts, and the district court heard that, talked about it in the findings, and resolved that, and found McEwen or McCowan, however she pronounces it, and he found Hendrix credible. And so, I mean, isn't that the end of this? I mean, we don't get to second guess that.
Your Honor, a physician who treated him, if you contrast a layman and the nurse.
We can't do that contrast, though. That's a finding of fact, and it's based on demeanor, appearance, how they respond to questions, none of which are we allowed to second guess, right?
Your Honor, he did not, the district court did not really refer directly to Dr. Brown, her testimony contrasting against Mr. Hendrix and the nurse.
Mr. Dietz, I do recall that the district court specifically addressed Dr. Brown's comment about Mr. Hendrix wanting to cease his medications in order to hasten death. Is that correct?
That is correct.
That seemed to be one of the statements that Dr. Brown really felt demonstrated that he was not thinking clearly. And the district court addressed that, evaluated that statement, and put it in the context of a lay person, including perhaps a 102-year-old person who might actually believe that ceasing their medications would hasten their death. And disregarded that or minimized that as evidence of dementia. So it appeared that the district court did analyze Dr. Brown's testimony with regard to dementia on its face.
The court did respond just as Your Honor has stated. But again, when you have a physician who has treated the man, and that is the way, that is the response, we contend that that's very arbitrary. It's not based on reason. It's not based on fact. And of course, that is just one of our undisputed facts that we contend.
Okay. All right, go ahead.
The second undisputed fact is that Mr. Woodard did not have the benefit of independent legal counsel prior to being presented with the transfer on death deed to sign. And he was presented with that deed by Mr. Hendrix. Mr. Hendrix acknowledged in his testimony that, yes, it's true that Mr. Woodard did not have independent counsel before he signed the deed, but he testified that, well, Mr. Woodard was his own legal representative. When we contrast that against the district court's response, the district court, we contend, totally missed the point of independent legal counsel. Because in reading, I'm sure you've read the transcript of the court's announced decision. District court stated that in regard to the issue of independent legal counsel, transfer on death deed does not have to be prepared by an attorney. Anyone can draft a transfer on death deed. There was no mention of the fact that Mr. Woodard didn't have the advice of legal counsel. We contend the district court totally missed the point for having independent legal counsel before signing a legal document, which certainly
Mr.
affects.
Dietz. So when we're looking at this, because of the standard of review, we're looking for evidence that the district court disregarded. And I believe you are contending that the district court did not regard this, but I believe the district court addressed this with regard to Mr. Hendrix' prior dealings with transfer on death deeds with Mr. Gregory and having no full estate planning in his history, not consulting attorneys with his estate planning, but in fact, making the decisions regarding the transferring of the land and just requesting documents to be written. Is there evidence that Mr. Hendrix engaged in estate planning that of the legal advice nature that the district court disregarded?
No, Your Honor, there was not evidence of that. However, independent legal advice, when one is, regardless, we contend that that's beside the point. I don't think it was very clear whether he would have had legal advice or not. I know what Mr. Gregory testified. He asked me to prepare a deed and I did that for him and he signed the deed and I recorded it. But in this case, when you ask this man, a 102-year-old man in a long-term care who was he was taking fentanyl and morphine, when you ask that man to sign a deed which changes the distribution of the property in his estate, he certainly is entitled and should have independent legal counsel. Very important in a case like this.
And so is it your contention that when he went and requested changes in 2013, when he was 96, that he was getting legal advice from Mr. Gregory about that?
I don't think there's any evidence one way or the other on that, Judge.
Well, I thought Mr. Gregory testified that he did not provide him advice regarding that.
He did not at that time. I think it's clear that Mr. Gregory said the deeds that he prepared for them historically, that he would come in and say, this is what I want done. And Mr. Gregory would do that. Now, those were times when he was not in a nursing home. He was not 102 years old.
He was 96.
He was not taking drugs.
He was not taking any medications when he was 96 and he requested those changes?
Your Honor, there was not evidence one way or the other on that. I agree. Yes. But certainly when you look at a number of the undue influence cases in Kansas, Cresto, estate of Farr, estate of Moore, estate of Bennett, it is interesting that in each one of those cases, there was a benefit of independent legal counsel. And those are very significant cases on the issue of undue influence in Kansas. So
Well,
I
in
would like to
Cresto,
highlight that.
right, I mean, Cresto's quite distinguishable from here.
It is. It's an unusual case.
Okay.
There
All
was,
right,
there was legal counsel involved, but the district court found, which is then affirmed by the Supreme Court, that really there was essentially a conflict of interest between the attorney who drafted the document and then Mr. Logan, who supposedly advised Mr. Cresto on that.
Well, and Mr. Cresto disinherited all of his children in that case, which is significantly different than the issue at hand here.
Yes.
Okay, so we've addressed Dr. Brown and the lack of independent counsel, which you contend was ignored by the district court. What other items do you think the district court arbitrarily disregarded? Because as Judge Atchison pointed out, the district court did address a lot of these issues.
We contend that he addressed a lot of issues, but what he did was arbitrary. And I would like to go on with another undisputed fact.
Mr. Dietz, I'm sorry, can you explain what makes it arbitrary?
What is arbitrary is when you have, again, a physician who treated the man, who knows about his health condition. And when that's contrasted against what the proponent of the document in question testifies to, and what a nurse at the long-term care center testifies to, I understand what the court is saying, that, well, nevertheless, he weighed the evidence. He just didn't give significant weight to the doctor, but that's arbitrary.
Well, I would also contend, though, that the doctor did not testify that he was suffering from dementia and he was incapable of understanding. That was not the doctor's testimony.
Our contention would be that if a doctor, a professional who has examined a person, puts down in her notes that that man exhibits dementia, that he shows dementia, that that is significant. And certainly she's the one that the nursing home relies on. They don't rely upon the nurse's opinion. They treat that man as being treated based on a doctor's examination and professional opinion.
Mr. Dietz, I saw no evidence that his treatment plan involved anything related to dementia.
His treatment plan, well, no, it was the doctor's opinion from her examination.
Right, but then there would be a treatment plan related to that.
And when she testified, there were in her testimony, someone at 102 years old in a long-term care facility, very common to see dementia. That's not unusual, but that's a significant fact we contend.
Okay.
Yes.
Okay. All right, go ahead.
A third undisputed fact is Mr. Woodard's physician, again, I'm returning to Dr. Brown, testified when questioned if she knew what a real estate deed was, that she did. She knew what such a document was. That certainly she's executed a document herself, her and her husband. And she was questioned whether she would have any concern about a person in Mr. Woodard's condition and under the influence of the drugs that he was being administered. Would she have a concern about a person signing a legal document such as a deed? She testified very directly that yes, she would. And the response of the court was that, well, Mr. Hendrix, the proponent, talked with Mr. Woodard about the transfer on death deed on September 12th and 13th before he fell and injured his head on the 14th and was being treated with fentanyl. But there was nothing suspicious about that because he didn't sign the deed until September 17th. Now that's an arbitrary disregard, is what we contend of the physician's testimony, which is very important in a matter like this.
Mr. Dietz,
Yes.
was Dr. Brown asked at trial when she last saw Mr. Woodard and examined him? And if so, what do you remember
She
when
did.
that was?
She saw Mr., if I may, Your Honor, she saw Mr. Woodard on the 14th, the day that he fell. On the 17th, he signed the deed on the 21st of September, 4 days following the signing of the deed is the last time that the evidence showed that she saw Mr. Woodard prior to his death on October 7th.
Thank you.
I will address a fourth undisputed fact that we contend. A daily chart was kept at the long-term care facility where Mr. Woodard was residing, which monitored his behavior symptoms. The 5 consecutive days prior to September 17th, the day that the deed in question was signed. And on September 17th, the day that it was signed, the chart showed that Mr. Woodard exhibited hallucinations and delusions at some point in time each of those days. They weren't during the hours or the specific time that the deed was signed. It was signed early in the afternoon. But that is significant. In other words, certainly all those days, in other words, it seemed to be, if not seemed, it was consistent that he was exhibiting symptoms that would be very significant in a matter like this. But the district court addressed this in his decision, stating that, well, since the behavior symptom chart does not show that Mr. Woodard was exhibiting hallucinations and delusions during the hour that he signed the deed. In other words, well, if it wasn't marked on the chart at the time that he signed the deed, then, well, there's nothing suspicious about that fact. Again, if it's consistently showing that at some points during a day that this person, Mr. Woodard, is exhibiting hallucinations and delusions, that's a serious disregard of the matter, especially when we're talking about a serious matter of the distribution of his estate. The fifth undisputed fact is that in the evidence which came out in the trial, when Mr. Woodard died, which was about 20 days after the signing of the deed in question, Mr. Hendrix, the proponent, called Barbara Bartell to inform her of the death of Mr. Woodard. And as I recall, it was then a phone call maybe a few days later between Barbara Bartell and Mr. Hendrix. And Mr. Hendrix, Barbara Bartell, the issue of the real estate came up, and Mr. Hendrix or Mrs. Bartell informed him that, they have a deed, the 2013 deed, transfer on death deed, which conveys Mr. Woodard's undivided interest in the Osborne County land to Mrs. Bartell and her husband, John. The response of Mr. Hendrix, and keep in mind, this is at a time, not even a full month then after Mr. Hendrix has, he and his wife prepared the deed in question, had Mr. Woodard signed the deed. Mr. Hendrix testified he recorded the deed, had the deed returned to him. He had the deed in his possession at this time. His response was, well, I'll have to wait until I get a death certificate so I can get into the safe deposit box. That is a very questionable circumstance. The the response of the district court was, well, essentially the district court thought, well, this would be normal. That, and it certainly shows something about the thought process of Mr. Hendrix, because undue influence is essentially, it's a chain of, based on suspicious circumstances, which typically is a chain of events over a period of time. And in this case, let's think about it. What we have is a 102-year-old man who had very poor hearing and vision, which was evidence at court. He was a resident of a long-term care facility and therefore in a very restrictive environment. And he was very dependent upon the staff at the nursing home and on Mr. Hendrix, who was his, had a confidential relationship with him.
Mr. Dietz, was there testimony in the trial regarding the last time Ms. Bartel spoke with Mr. Hendrix regarding the North Place?
Your Honor, I do not believe there was any evidence of when she would have talked with him. I do not believe so. I've reviewed the transcript, but I do not believe there was.
I didn't see anything. I just wasn't sure if I missed something in that regard.
I do not think so, Your Honor. Of course, there was evidence in the case. There is a document admitted into evidence, which when he sent the October 2013 deed by mail to Mrs. Bartell and her husband, there is a note that's in evidence about him. Certainly, it was very obvious his intent was that he's giving that land, his interest in that land to them upon his death. And there was some other discussion of life and how things were going with the weather and crops in that letter. That was in evidence. I do know that I think it is in evidence that Mrs. Bartell, though, had been through Osborne and visited him from time to time through the years. Yes, but there was no evidence of any specific dates or occurrences. If I may go on, there was evidence that, and I know we've had quite a discussion about this today, that he did have dementia and end-stage heart disease. Because I think that was, that may not have been in the memo Your Honor referred to, but I know it is in the court's testimony that he had dementia and end-stage heart disease. He was being treated with fentanyl and morphine. He had sustained a severe head injury from a fall 72 hours before signing the deed in question.
Mr. Dietz, can we talk about the transfer in 2013 of the North Place?
Yes.
Because there's evidence that Hendrix was intended to have part of the North Place in 2013. Is there evidence or testimony regarding why that would have changed?
No, Your Honor. If I understand the court's question or the statement the court, Your Honor, just made, evidence that it was intended that Mr. Hendrix have the property in 2013?
Well, yes, sir. In 2002, I believe there was a transfer on death deed to Hendrix and Phyllis. Yes. And then in March 2013, there was a transfer on death deed to Hendrix and his wife.
Yes. 2000, well, 13. Earlier, I think it was March of 2013, it was Hendrix and his wife.
Correct. And then October, there's one for Barbara and her husband.
That's exactly right.
And so
was
what is the evidence? What was the change from March 2013 to October 2013?
There was no evidence of any change.
Is it
Certainly.
possible that the actual intent was to add Barbara and her husband?
Was there evidence of that?
Yes.
The evidence was a letter that states that's what he wanted to do, and he had executed a deed and sent it to her.
That he was intending to take Hendrix off of it in October.
He
Is that-
he didn't state in the letter that, well, I'm going to take Hendrix off of it. He simply executed a deed that granted this property interest in the land in Osborne County to Barbara Bartell and her husband, John Bartell.
And he said something in the note about also Barbara's siblings, right?
I believe he did. Yes. Yes.
Okay, so your contention is that there, for some reason, he just decided to take Hendrix off entirely, even though Hendrix had been on it for over a decade, and switch it to Barbara.
Yes.
Okay,
He had already given property to Hendrix. He'd already given property to him before.
yes, it's clear. Yeah, that
Yes.
Hendrix was the favored beneficiary. Okay,
I may go on then.
Mr. Dietz, I know we've been asking you a lot of questions and allow you to go over your initial time. Would you be able to hit the highlights that you want and so you can reserve your rebuttal time? I don't want to take the rebuttal time away from you.
I can, Your Honor, absolutely. I just wanted to close with the points that I was making that we claim are, they consist of significant suspicious circumstances. I'm going to return to the physician again. She testified that he had cognitive issues. And finally, when we look at this, the person who has a confidential and fiduciary relationship with the proponent, in this case, is the one who actually, well, through his wife, prepares the document, the transfer on death deed form that is self-serving. The person in the confidential relationship, he and his wife make the deed. The deed is for the purpose of benefiting himself, and which is very significant. And when you look at a chain of events that consist of undue influence, and we respectfully submit that the judgment of the district court should be reversed, because we contend that the evidence, the facts in this case, and the evidence before the district court was so significant that it proved suspicious circumstances, and there was an arbitrary disregard of the evidence, undisputed evidence, which was presented to the court. Therefore, we respectfully request that the appellate court would reverse the decision of the trial court, thereby resurrecting the October 2013 deed. Thank you, Your Honors.
Thank you, and you still have your rebuttal time.
Thank you.
Mr. Katz?
May it please the court, Your Honor. I thought we were going to have a much larger discussion about the standard of review in this case, because as you can see from my brief, the appellants and the appellees did not necessarily agree that the standard of review in this case was the arbitrary disregard of undisputed evidence, or some extrinsic considerations such as bias, passion, or prejudice by the trial court. It appears at this point that the appellants agree that the standard of review in this case is the arbitrary disregard of undisputed evidence, and aren't arguing that there was any sort of bias or passion or prejudice of any sort. So as you're all aware, when considering the sufficiency of the evidence to support the trial court's findings of fact, The appellate court does not reweigh the evidence or pass on the credibility of witnesses, which is exactly what it appears the appellants are asking you to do in this case. I've responded to every one of the appellant's arguments today in my brief in regard to the questions of fact that they keep bringing up about the court they arbitrarily disregarded all these facts, but I don't think there was any fact that they arbitrarily disregarded. I don't think there was any fact they disregarded whatsoever. And there's the arbitrary disregard of undisputed facts. I don't think there was a single fact in this case that left any dispute or was undisputed. They all were disputed. So I guess that's where we start from this. I guess let me talk about questions of law for just a second. There were a few questions of law that were done by pretrial briefs at the trial court. Those were the burden of proof on the undue influence claim and also the issue of the prima facie case of validity of the deed. Those questions were established at the district court level. And as far as I can tell, the appellants are not arguing and have not argued that those should be reversed on appeal. So the majority of everything that Mr. Dietz is talking about and the appellants are arguing is just, again, a question of fact. I kind of want to discuss a little bit as much as this court would like me to do, even though I've already discussed every single one of the points that he's brought up in my reply brief. Dr. Brown, as Judge Hurst has pointed out, Dr. Brown never made a finding of dementia. In all the years she was his doctor, she never made a finding that essentially that Wendell Woodard had dementia. The only mention of dementia in any of his notes, and there were several hundred pages of notes from both the hospital and also from the long-term care facility. In all those notes, the only mention of the word even dementia was put in 4 days after he signed the 2018 transfer on death deed. It was a single memo that she testified was only done because there was an issue about his weight loss, and somebody was worried that he had weight loss, and so she wrote a letter back just to stick in his file. In regard to independent legal counsel, which is the second thing that they brought up that they claim the court arbitrarily disregarded, independent legal counsel, the court never just shrugged it off like the appellants want you to believe that they did. It's not required by statute, and he wasn't the type of person who ever let any attorney draft any sort of large estate plan. And like you heard earlier, Attorney Paul Gregory wasn't the type of attorney that he had that would tell him exactly what he was doing with the documents. He only drafted the documents he was sort of asked to do. There was also a continued discussion about this fentanyl and morphine. It's my understanding the morphine was allowed to be given to him when he needed it. He wasn't on some sort of steady drip of morphine, and he only got that when he needed it. It's also my understanding in regard to the fentanyl, and the testimony was he was on a patch version of fentanyl, which I think maybe a 3-day window for the patch. And the reason for the patch had nothing to do with his fall. He was on that, I believe, prior to this fall that he had on the 14th. He was on that because I believe he had some sort of arthritis, I believe is what the testimony was. And he was given the patch because it was a steady dose, so it wouldn't affect him mentally. In regard to, I don't know the last time that the Dr. Brown, again, I'm trying to just step through what the appellants were arguing a minute ago. I don't know the last time the doctor saw him, but I think her memo was on the 21st. I don't know if she necessarily saw him. I think that memo was based on somebody's call, it's my understanding, a call to her made from somebody at the long-term care facility. And then she wrote that note to say, yeah, I understand he's losing weight because he has all these other problems. It's going to continue to happen.
Mr. Katz,
yes.
Is there evidence in the record as to the value of this parcel of land?
There is not anything in the record, Your Honor, and unless the court would like me to say exactly what it sold for, because this property has now been sold, and I will tell you what it sold for. But the value of there's no evidence of the value of this property in the record now.
What did it sell for?
Okay, yeah, it sold for, I believe, over $1.2 million, somewhere in there, 1.2 to 1.3, I think is what it sold for.
Okay, and is that the whole parcel?
That's the whole 700 acres, yes, Your Honor.
Okay, it's the the entire interest that the court was addressing. I mean, the whole, okay.
Yes.
Should we look at the evidence here by slicing it and dicing it into each individual piece? Or is there some cumulative effect of the circumstances that we can look at the whole of it and say collectively it is suspicious? Because it seems to me you can take the whole picture and look at it, and there's one that would say that Mr. Hendrix was being this dutiful nephew and continuing to look after Mr. Woodard's affairs, and realized there might be a mistake on this deed, and went in and changed it and had him sign it when there's evidence that Mr. Woodard wasn't lucid all the time and had fallen and had these issues. There's another, of course, that would paint that as obviously very self-serving, and it's conferring a benefit on Mr. Hendrix that he otherwise didn't have. He was secretive about it. He had his wife, who was either a paralegal or a legal secretary, draft up the deed. I mean, which isn't, a difficult transaction. But then afterwards, after Mr. Woodard dies, he's somewhat circumspect about discussing it with Ms. Bartell in this telephone conference. One could say that all of that collectively is rather roguish. And so what are we supposed to do with that?
Well, I think there's 2 points that I would like to make based on what you just said. One is the cases are very clear that this is a totality of the circumstances sort of evidentiary finding. The court is to weigh all the evidence, take into account everything you're saying. So when you talk about parsing this out or slicing these into little pieces, it could look exactly like the appellants are arguing, is that it could look like that it is suspicious. But that's not what the court is supposed to do in these situations. It's supposed to take into account all of the considerations, all of the testimony, and not only the testimony, but also the credibility of the witnesses, and weigh everything together. And at the end of the trial, make a decision as to if there was clear and convincing evidence. And again, that's a pretty high standard, clear and convincing evidence of suspicious circumstances. So I think that answers the first part of your question. The other part of the question, or the other important part that I want to make sure that is said, this is why I believe this is why the standard of review exists in this case. The standard of review is an arbitrary disregard of undisputed evidence. So if you look back at this, and because it's fact-based, because it's completely based on the testimony, it's based on the evidence, it's based on everything that the judge observed during the trial, it's not a substantial and competent evidence standard. It's an arbitrary disregard of any undisputed evidence. So was there an arbitrary disregard of undisputed evidence? In this case, the answer is no. So I think that's why that standard exists, because this court is not supposed to look back at those cases, or look back at these cases and say, well, if you parse these things out, then this is what it would appear to be, when it's not. It's the totality of the circumstances.
What if the standard were clearly erroneous, that we were to look at the court's findings and could set them aside if they were clearly erroneous? Would we have a different outcome here?
No, I don't think so. I think in this situation, even if the standard were clearly erroneous, the court didn't. There was nothing. Again, the court didn't take into consideration on this. I think that's the sort of the same analysis that you would do. And honestly, I do think even if this court and the three of you were to look back at the record and decide that it appears that there are suspicious circumstances, and the burden should have shifted, because if there were suspicious circumstances, the burden would have shifted to my client to prove just by a preponderance of the evidence that there wasn't suspicious circumstances, wasn't undue influence, excuse me. I think we still would have met that burden as well. So does that answer your question?
Yes, thank you.
Okay.
Mr. Katz, when Mr. Hendrix was going through to get Mr. Woodard's affairs in order, did he find any other items that needed corrected? I didn't see anything in the record regarding that.
And I don't want to
Was
speak
there?
outside the record. I don't want to speak
No,
outside the
I'm
record.
asking what's in the record.
Sure,
Did he
sure.
find?
I think it's in the record that he did find, he looked at all the deeds and he looked at all of the CDs and everything at the bank accounts. There were no other things that he made any changes to. This is the only thing that he helped his uncle to make the change to correct what was incorrect based on what he had been told and what his uncle told him was incorrect. And there is testimony that you're absolutely correct, like you stated earlier. He's absolutely favored in every single thing, not everything, but is absolutely favored in Wendell's estate plan. There was a deed done on Butler County property, 80 acres that went to my client. I think that was done in 2002, somewhere right around there. There was there's a home place, what he called the home place in Osborne County, that also went to my client by transfer and death deed. Again, I think that was of record from around 2000 to 2004, somewhere in there. The CDs were in transfer on death form or joint tenancy, I believe, or maybe probably beneficiary form, I believe, to my client.
Mr.
Same with
Katz,
his bank account.
was there was testimony from Mr. Hendrix that it was his understanding that the North Place was to go to he and Barbara. I believe I recall some testimony from Edith about the cousins, which would be Barbara and her siblings, I think, correct? Getting it. Was there testimony from anyone other than Hendrix that Hendrix and Barbara were to share the North Place?
I don't believe so, Your Honor. No.
Thank you.
But having said that, I mean, it is clear based on reading everything that had happened on this North Place. And so there may not have been specific testimony from anybody stating that this North Place was supposed to be shared between Barbara and my client Roger. It was clear from the record, as you stated earlier, there was a will done in 1997 that gave everything that Wendell had over to Phyllis Hendrix. And if Phyllis Hendrix had predeceased Wendell, then everything would have went to Roger. So that existed, and that's still in existence upon his death. That was the last will and testament of Wendell Woodard. And he did the deeds, like you stated earlier. He did the deeds, I believe, in 2002 or 4 that transferred this property, would have transferred this property upon his death over to my client and his mother. And then another deed was done in 2013, beginning of 2013. The transfer of this property would have transferred this property to my client upon death over to he and his wife. And then again, there was no explanation as to why that second 2013 deed was done. So. And unless you guys have any further questions, I don't have anything else.
Thank you, Mr. Diaz. We're really ready to hear your rebuttal.
Thank you, Your Honor, and I'll be very brief. Judge Atchison made a point that I did not articulate well enough myself, but I was attempting to do that at the end of my oral argument, where I went through the various facts in this case. And I did say that really undue influence is typically going to be based on a chain of events. It's usually not going to be one isolated event or occurrence. But certainly, this is a classic case of when you look at everything that happened here, when you look at, again, the age of this gentleman, the state of his physical health, the state of his mental health, when you look at the medication he was on, the restricted environment he was in, when you look at who prepared the document that is in question, it essentially is, by way of his wife, the proponent, the one who has benefited from what happened here with that deed. When you look at the totality of it, in going to the nursing home, having him sign that a few days after the fall, which he knew about, talking about Mr. Hendrix, recording the deed, having the deed returned to him. Interesting that he didn't put it in Mr. Woodard's safety deposit box, which he mentioned. He has that sent to his home in Andover, Kansas. When you start at the beginning and because at the beginning, Mr. Hendrix goes to the nursing home and decides that he'd better, and it's pretty obvious, keep in mind, Mr. Woodard died 20 days after this deed was signed. And when Mr. Hendrix went to the nursing home, certainly saw the situation that Mr. Woodard was in, his health condition. He then gets a hold of his wife, this is in the evidence, who's a legal secretary, has her check with the Register of Deeds, but let's double check and see how this, how his property is owned. When he discovers that that he is not a grantee of some of the property, then he calls his wife and says, which he testifies, which is very self-serving. Mr. Woodard is gone, testifies, well, I talked to Wendell and said, you know, now this one deed shows I'm not on this deed. Is that what you want? He testifies that Mr. Woodard said no. So then he calls his wife and gets a deed to get a deed ready. Interesting, I didn't go through this in my initial oral argument, but he did call Mr. Gregory. If he thought it wasn't necessary for legal advice, interesting that he did call Mr. Gregory, he claims. And he says he makes a call, it was sometime on, I believe the Friday that Mr. Woodard falls at the nursing home. And he makes one call to Mr. Gregory, says that he wasn't able to get him. Mr. Gregory testifies, my secretary and I were in that office every day that week. We were there from the time, you know, from 9 o'clock till 5 o'clock. But at any rate, he calls his wife, but he says, well, I didn't get a hold of a lawyer because I couldn't get Mr. Gregory. So he has his wife get the deed ready. He drives back, that was on a Friday. He goes back to Andover, Kansas, which is about 3.5, 4 hours away, brings the deed back on Monday, goes in, has the deed signed, records it, tells the Register of Deeds to return the deed to him. And 20 days later, when Mr. Woodard dies, it is interesting to note that if he was concerned about what was in the safety deposit box to determine who owned the property, who owned his property, he knew that when he talked with Barbara Bartell, he had the deed in his possession and never disclosed that. Again, that's the final act of a chain of events that certainly strongly show suspicious circumstances. Judge Atchison, your point is well taken. You articulated it much better than I did, but I think that that's what you have to look at in this type of a case. And certainly I do believe that, you know, I realize there was testimony from Mr. Gregory. Well, when he wanted something done, I did it. I really didn't, I don't know that Mr. Gregory said I didn't advise him. He just said, I did what he asked me to do. Well, it would have been very important for Mr. Gregory or some lawyer to be there to tell Mr. Woodard what this document consisted of and what the effect that it would have, because it did amount to not the full 700 acres of land, but an undivided 1/2 interest in it. And so in conclusion, it's an obvious chain of events that strongly prove suspicious circumstances. Again, when I look at the cases, the Cresto, Bennett, and Farr, none of those cases had a fact situation like this, where in all those cases, an attorney drew the documents, and an attorney, there was legal advice afforded to the makers of those documents. We don't have that here. Thank you.
Thank you. We appreciate, excuse me. Okay. We appreciate both of your arguments in this case. Good arguments, and we will take this case under advisement and give you a written opinion as soon as possible. Thank you very much and have a good day.